Sometimes the biggest battles start with something really small. In this case, a single security light on a shed. But believe me, this one little light sparked a full-blown legal fight between a homeowner and his HOA, and it all came down to a promise made more than a decade ago.
So, let me ask you this. Imagine you did everything right. You followed the rules, you got that written approval from your HOA, and you spent your own money on a project. Then years later, a completely new board comes in and says, yeah, nope, that's got to go. Can they actually do that? Well, that is the exact question we're digging into today.
All right, so our story revolves around two main players, a homeowner named Richard Morris and his HOA, the Towns at Paradise Valley Landings. For 12 long years, everything was totally fine. Then, all of a sudden, in 2022, a dispute over this long-forgotten approval just blows up and turns into a formal legal hearing.
Now, the timeline here is absolutely critical. Back in 2010, Mr. Morris gets the green light. Then, you fast forward a whopping 12 years to 2022, and boom, that very same light is suddenly a violation. Fines start piling up, and by 2023, they are in a courtroom trying to sort this whole mess out.
Okay, so let's break down the homeowner's argument first. At its core, it's really about a pretty simple idea. A promise that's been made and acted upon, well, it should be a promise that's kept.
And there's a legal name for that idea. It's called promissory estoppel. Basically, all that means is if somebody makes you a clear promise and you reasonably rely on it, you spend time or money because of it, they can't just pull the rug out from under you later. This was the absolute foundation of Mr. Morris's entire case. And here's the thing, he had the receipts. This is the exact wording from his 2010 application. It couldn't be clearer. It explicitly says he planned to install the light to the shed fascia board. No gray area at all. He even pointed to another approved light in the neighborhood as an example.
And the approval form itself? I mean, look at this. It's completely unambiguous. The approved box is clearly checked. And that box for approved subject to the following conditions? Totally blank. This was a simple, unconditional, straightforward yes.
But here, this was the homeowner's knockout punch. And it came directly from the HOA's own rulebook. Their covenants, conditions, and restrictions, the CC&Rs, literally said that if you have prior approval, you don't need to ask for permission again. He wasn't just right, he was following their rules.
Okay, now let's flip the coin and look at the HOA's side of the story. They argued that, look, this wasn't about them being difficult. This was about their financial duty, their responsibility to the entire community.
And the whole reason for their concern boils down to this one big number, almost $140,000. That's how much the HOA had recently spent on a massive project to replace all the shed roofs and fascia boards in the entire neighborhood.
And here's the problem. The HOA's contractor was really blunt about it. They warned that drilling anything into that brand new fascia would compromise it and, this is the important part, it would void the new 5-year warranty on all that very expensive work. You can see why the HOA was worried.
So to protect that huge investment for everyone, the HOA took a pretty big step. They officially updated their architectural guidelines. And this new community-wide rule explicitly banned all security lighting on sheds from that point on.
So this is the core of the conflict, right here. On one side, you have a homeowner with a very specific, unconditional, written approval from the past. And on the other, you have the HOA with this general duty to protect a brand new, expensive investment for the future of all 118 homeowners.
All right, so both sides laid out their case. The homeowner argued a promise is a promise. The HOA argued their financial duty to the community had to come first. So, what did the judge decide?
It's a tough call, isn't it? I mean, does a 12-year-old piece of paper really outweigh a fresh $140,000 community investment and the risk of avoided warranty? Let's see what the judge had to say. The judge ruled in favor of Richard Morris. Plain and simple. That old approval from 2010 stood firm against the new rules and the new warranty. The homeowner won.
So, the big question is, why did he win? Well, the judge's decision pointed to a really critical mistake. The HOA board actually admitted that before they signed that massive roofing contract, they did no due diligence. They never bothered to check for any pre-existing approvals, like Mr. Morris's, that might conflict with the new warranty.
And the judge basically concluded that
Yes, an HOA has a financial duty to its members, but that duty does not give them the power to just ignore or, to use the judge's word, disavow a legally binding agreement they'd already made. That 2010 approval was a done deal.
So the final order was crystal clear. First, the HOA had to let Mr. Morris reinstall his light, period. And second, they were ordered to pay him back for his $500 filing fee. So not only did they lose, but they had to foot the bill. You know, this whole thing is way more than just a story about one light. It actually offers some really powerful lessons for anyone who lives in a community with an HOA.
So what can we all take away from this? Okay, number 1, and this is a big one, always get approvals in writing. 2, look closely for any conditions or expiration dates. 3, actually read your own governing documents. You might be surprised to find the answer is right there in black and white. And finally, remember that due diligence isn't just for homeowners. This case proves HOAs have to do their homework too.
When you really boil it down, this verdict reinforces some huge principles. It says a specific written approval from the past can absolutely beat a new general rule. It says an HOA can't just wake up one day and decide to tear up an old agreement. And maybe most importantly, spending a lot of money on a new project doesn't automatically give them the right to erase rights they've already granted to homeowners.
And that leaves us with a really fascinating question to think about, doesn't it? As our communities grow and change and new problems pop up, how do we balance honoring the promises of the past with the very real need to adapt for the future? This case drew a pretty clear line in the sand, but you can bet that tension is always going to be there.